Act 2020 UK. Section 57, Statutory Purposes, Factors and Guideline Framework. This is one of the most important provisions in modern 10th century law in England and Wales. This video is suitable for bar students, judicial exam candidates, criminal practitioners, academics, and anyone seeking advanced understanding of sentencing structure in the UK. We'll look at Section 57 in full, examine each statutory purpose of sentencing, integrate related statutory provisions within the Sentencing Act 2020, discuss seriousness, custody threshold, totality, guilty plea reductions, and we explain how Sentencing Council guidelines operate alongside the Act, and then go ahead to demonstrate how advocates deploy these principles in court. So let's begin. Part 1. Section 57, the statutory purposes of sentencing. Part 1, Section 57, the statutory purposes of sentencing. The Sentencing Act 2020, Section 57, provides in Section 57, subsection 1, that this section applies where a court is dealing with an offender aged 18 or over in respect of an offense. This immediately limits the provision to adult offenders. And what is the operative duty here? Section 57, subsection 2 says the court must have regard to the following purposes of sentencing. Must have regard to. That phrase, must have regard to, imposes a mandatory consideration, not a rigid formula. And the purposes are Section 57, subsection 2a, the punishment of offenders. Section 57, subsection 2b, the reduction of crime, including its reduction by deterrence. Section 57, subsection 2c, the reform and rehabilitation of offenders. Section 57, subsection 2d, the protection of the public. Section 57, subsection 2e, the making of reparation by offenders to persons affected by their offenses. Philosophical and statutory foundation of adult sentencing. These 5 purposes form the philosophical and statutory foundation of adult sentencing, but they do not operate in isolation. However, to understand Section 57 fully, we must examine the surrounding statutory structure. Seriousness, the anchor of sentencing. Seriousness, the anchor of sentencing. Before applying the 5 purposes, a court must determine seriousness. Section 63 of the Sentencing Act 2020 provide in its Section 63, subsection 1, that the court must consider the seriousness of the offense. So, Section 63, subsection 2, states that in considering the seriousness of an offense, the court must consider A, the offender's culpability in committing the offense, and B, any harm which the offense 1. caused, 2. was intended to cause, or 3. might foreseeably have caused. This provision anchors punishment in proportionality. It is worthy to note that seriousness limits judicial discretion. It ensures that deterrence or public protection cannot inflate a sentence beyond what culpability and harm justify. Thus, punishment under Section 57, subsection 2A is bounded by Section 63, Part 3, reduction of crime and deterrence. Now, returning to Section 57, subsection 2B, the reduction of crime, including its reduction by deterrence. Deterrence operates both generally and specifically. However, deterrence must operate within proportionality. A court cannot impose a sentence greater than justified by seriousness simply to deter others. This balance reflects the structured nature of the act. Rehabilitation and community disposals. That is part 4. Rehabilitation and community disposals. Section 57, subsection 2C states that the reform and rehabilitation of offenders rehabilitation becomes particularly relevant when considering community orders. Section 204 of the Act provides in each section 204 subsection 1, a court may make a community order in respect of an officer if the offense is punishable with imprisonment. Community orders are designed precisely to promote reform. Similarly, suspended sentences under Section 189 allow custody to be imposed but not activated immediately, thus reflecting a balance between punishment and rehabilitation. Protection of the public and the custody threshold. Part 5. Protection of the public and the custody threshold. Section 57, subsection 2D states the protection of the public. Protection becomes central when assessing whether custody is necessary. Section 230 establishes the custody threshold. Section 230, subsection 2, the court must not pass a custodial sentence unless it is of the opinion that the offense or the combination of the offense and one or more offenses associated with it was so serious that neither a fine alone nor a community sentence can be justified for the offense. And this is critical. Custody is not automatic. It must be justified by seriousness. Protection of the public may support custody, but only if Section 230's threshold is met. Part 6. Reparation and compensation. Section 57, subsection 2E the making of reparation by offenders to persons affected by their offenses. This purpose is operationalized through compensation orders. Section 55 of the Act provides in each section 55 subsection 1, a court by or before which a person is convicted of an offense may make a compensation order. Reparation reflects restorative justice principles. It places victims within the sentencing framework. Part 7. Reduction for guilty plea. Although Section 57 sets out purposes, sentence calculation must also consider guilty plea reductions. Purposes of sentencing, that is the foundation. Section 57 sets out the purposes of sentences for offenders aged 18 and over. Section 57 subsection 1 states that the court must have regard to the following purposes: A. The punishment of offenders. B. The reduction of crimes, including deterrence. C. The reform and rehabilitation of offenders. D. The protection of the public. E. The making of reparation by offenders to persons affected. This section answers the question, why are we sentencing this person at all? It provides the philosophical and statutory foundation of sentencing in England and Wales. So, when discussing arson or criminal damage sentencing principles, Section 57 governs the objectives. Section 73, subsection 1, in determining what sentence to pass on an offender who has pleaded guilty to an offense in proceedings before that or another court, a court must take into account the stage in the proceedings at which the offender indicated the intention to plead guilty and the circumstances in which the indication was given. This interacts with Sentencing Council guidelines on guilty pleas, often allowing up to 1/3 reduction. Thus, statutory purposes operate alongside structured reductions. Totality principle, part 8. Where multiple offenses are involved, Section 166, in each subsection 166(1), if an offender is convicted of 2 or more offenses, the court must consider whether the total sentence is just and proportionate. This ensures cumulative punishment remains fair. Again, proportionality governs the exercise of statutory purposes. Part 9, Sentencing Council guidelines. Section 59 of the Act provides in each section 59 subsection 1 that every court A must, in sentencing an offender, follow any sentencing guidelines which are relevant to the offender's case. This is mandatory unless contrary to the interest of justice. Thus, statutory purposes under Section 57 operate within offense-specific guidelines. Starting points, category ranges, aggravating and mitigating factors. Judges must determine offense category, identify starting points, adjust for aggravation or mitigation, apply guilty plea reduction, ensure totality, articulate statutory purposes, Part 10, integrating sentencing structure. The full structure becomes determine seriousness, Section 63, apply custody threshold, Section 230, consider purposes, Section 57, follow guidelines, Section 59, apply guilty plea reduction, Section 73, apply totality, Section 166, consider compensation, Section 55. Section 57 is therefore central but not isolated. It guides the philosophical justification of the outcome. Part 11, advocacy application. In mitigation, counsel may say punishment is inevitable, protection of the public is minimal, rehabilitation is strong, immediate custody would undermine reform, reparation can be achieved through compensation. All this demonstrates compliance with Section 57. In conclusion, Section 57 of the Sentencing Act 2020 in the UK provides that the court must have regard to the following purposes of sentencing: A, the punishment of offenders; B, the reduction of crime, including its reduction by deterrence; C, the reform and rehabilitation of offenders; D, the protection of the public; and E, the making of reparation by offenders to persons affected by their offenses. But those purposes operate within a structured statutory framework, which include Section 63, seriousness; Section 230, custody threshold; Section 59, guidelines; Section 73, guilty plea; Section 166, totality; Section 55, compensation. Together, they form a coherent sentencing architecture. Section 57 provides the philosophy. The surrounding sections provide the mechanics. Understanding both is essential to mastering sentencing law.